Good afternoon. This is a judicial decision regarding the bail application for Michael John Dundee. As the presiding judges, we will evaluate the arguments presented by both the defense and the prosecution, and then arrive at a reasoned decision on whether to grant bail to the defendant. Defense arguments. The defense has countered the prosecution's points with the following arguments and relevant articles from the Canadian Criminal Code. Presumption of innocence. The defense underscores that the defendant is presumed innocent until proven guilty, as reflected in Section 11D of the Canadian Charter of Rights and Freedoms, and should not be deprived for their liberty without substantial justifications. Second, stable community ties. The defendant has strong ties to the community, including stable residence, family connections, and ongoing employment, which significantly reduce the risk of flight. Section 515(10)(b) considers the necessity to ensure the defendant's attendance in court. Third, willingness to comply with conditions. The defendant is willing to comply with stringent bail conditions, including surrendering their passport, regular reporting to authorities, and wearing an electronic monitoring device, as outlined in Section 515(4)(a) and (e). 4. Impact on the defendant's life. The defense highlights the adverse impact of continued detention in the defendant's personal and professional life, arguing that it would cause undue hardship, which the court should consider under Section 515(10)(c) for maintaining confidence in the administration of justice. Commitment to rehabilitation. The defense has presented a plan for the defendant to enter the Trafalgar Addiction Treatment Center to address his addiction, which will provide strict surveillance and support, reducing any risk posed by his release. This plan is supported by Section 515(10)(a) regarding public safety and the protection of the public. Lack of concrete evidence. The defense argues that the prosecution's fears of reoffending and interfering with witnesses are speculative and not backed by concrete evidence. Additionally, there is a lack of evidence regarding the alleged weapon used in the assault, which aligns with Section 515(10)(c) in assessing the strength of the prosecution case.
Good afternoon. Now we will go on with the prosecution arguments. The prosecution has made a compelling case against the granting of bail, citing several key points and relevant articles from the Canadian Criminal Code. First, we have the risk of flight. The prosecution argues that the defendant poses a significant flight risk due to their extensive international connections and financial resources, which could enable the defendant to abscond and avoid trial. This concern aligns with Section 515(10)(b) of the Canadian Criminal Code, which considers the likelihood that the accused will fail to attend court as required. Second, we have the risk of reoffending. It is submitted that the defendant has a history of similar offenses, suggesting a high likelihood of reoffending if released on bail. Section 515(10)(a) addresses this concern, emphasizing the need to ensure the protection or safety to the public, including any victims or witnesses. Then we have the interference with witnesses and evidence. The prosecution fears that the defendant, if released, might interfere with witnesses or tamper with evidence, thus risking the integrity of the judicial process. This is also covered under Section 515(10)(a), which allows for detention if there is any substantial likelihood that the accused will commit an offense or interfere with the administration of justice. Moving further, the seriousness of the offense. The prosecution emphasizes the severity of the charges, arguing that the serious nature of the alleged crime warrants the defendant's detention until trial. Section 515(10)(c) supports this, considering the necessity of detention to maintain confidence in the administration of justice, given the gravity of the offense and the circumstances surrounding it. Last, we have the public safety. Given the nature of the alleged offenses, the prosecution maintains that the defendant's release could pose a threat to the public safety, as outlined in Section 515(10)(a). In this bail application, the onus is reversed under Section 5156(b)(1) of the Canadian Criminal Code. This means that it is the responsibility of the defense to show why bail should be granted, rather than the prosecution having to prove why it should be denied. The defense must demonstrate that the defendant does not pose a flight risk, will not reoffend, and will not interfere with the administration of justice if released on bail.
Good afternoon. Now we're following to judicial decision and reasoning. After careful consideration of the arguments presented by both the defense and the prosecution, we have reached the following decision regarding a bail application for Michael John Dundee. First of all, presumption of innocence and bail conditions. The presumption of innocence is a fundamental principle of our legal system, as outlined in Section 11D of the Canadian Charter of Rights and Freedoms. The defense argues that denying bail would undermine this principle. They have proposed strengthening bail conditions to ensure that the defendant does not possess a risk if released. These conditions include electronic monitoring, surrendering the passport, and regular reporting to the police, as outlined in Section 5152 and 5154 of the Canadian Criminal Code. These measures aim to mitigate any risk associated with granting bail and ensure the defendant compliance with bail terms. Second, flight risk and assessment. The prosecution argues that the defendant possessed a significant flight risk due to the severity of the charges and potential sentence. The defense counters this by highlighting the defendant's strong community ties, including family and employment. They also propose strict bail conditions to mitigate the risk. Evaluating both sides, we found that the proposed conditions, including electronic monitoring and regular reporting, should sufficiently mitigate the flight risk, as required under Section 51510A of the Criminal Code. 3. Risk of reoffending and public safety. The prosecution highlights the risk of reoffending given the defendant's history of violence and the nature of the current charges, which include assault with a weapon and offering threats. They emphasize that the defendant's past behavior suggests a pattern that poses a threat to the community. The defense, however, has proposed that the defendant enters the Trafalgar Addiction Treatment Center, where he will be under strict supervision. This commitment to a rehabilitation program is intended to address the underlying issues contributing to the defendant's behavior and reducing the likelihood of reoffending. The proposed treatment, combined with the bail conditions, addresses that the public safety concerns outlined in Section 51510B of the Canadian Criminal Code by ensuring that the defendant is closely monitored and receives appropriate treatment. The risk to public safety, including the safety of the victim and the witness, is significantly mitigated. 4. Public confidence. Maintaining public confidence in the judicial system is crucial. The prosecution argues that granting bail could undermine the confidence due to the serious nature of the alleged offenses. The defense contends that the strengthening bail and the defendant's commitment to rehabilitation demonstrates a balanced approach that upholds the presumption of innocence while addressing public concerns. By imposing strict bail conditions, the court can maintain public confidence. This balanced approach aligns with Section 51510C of the Canadian Criminal Code, which considers the importance of maintaining public confidence in the administration of justice.
Given the accused's commitment to enter a rehabilitation facility, specific conditions are recommended for the 14 days between the bail hearing and the commencement of his treatment. These conditions under Article Section 515, 2 and 4 of the Canadian Criminal Code include, firstly, residing within the area of Ontario. This condition ensures that the accused does not leave the geographical area, which makes it easier for law enforcement and the court to monitor him, and also reduces the risk of fleeing to avoid prosecution and maintains the court's authority over him. Secondly, abstaining from communicating with Sue Charlton and Sarah Connor. Given the violent history of threats made by the accused towards Sue Charlton, it is important to protect the safety and well-being of the victims. In this condition, prohibiting any form of communication protects the victims from potential threats, intimidation, and harassment, safeguarding their well-being during the pretrial period. Lastly, refraining from going to any place the victim or witness might be. This condition prevents contact between the accused and the victims or the witnesses, minimizing the risk of confrontations and ensuring their safety. It also reassures the victims and encourages their cooperation with the judicial process. In summary, the accused will comply to these conditions due to the strict surveillance and care and confidence of the justice system. These include no contact with the victim, Sue Charlton, rendering his passport to the authorities, commencing his treatment at Trafalgar facility, and 24/7 monitoring.